facing the police every single day.
Local police and other law enforcement agencies have been obtaining court orders to compel local cell carriers to disclose the location data of people they suspect of crimes. But significantly, these have not been probable cause search warrants as permitted under the Fourth Amendment to the U.S. Constitution. They've simply been requests from courts for the business record documents of cellular carriers. And in previous decisions, it's been held that business records are subject to court order and can be obtained by law enforcement for whatever purposes they wish. Okay, so there was a burglar ring operating. I think it was in 2011. They were caught. The ring leader was a guy named Timothy Ivory Carpenter, who was accused of planning these crimes. I guess some of his other cohorts fingered him as the boss, and so he got in trouble. He petitioned, so he was first convicted from. I should explain that the FBI, after they got his name, got a court order to cause the cellular carrier in the region to turn over the records of his cell phone location, which did identify him as being present in the location and time of 4 of the burglaries. He was found guilty in court, sentenced, and for like a huge number of years, more than several lifetimes, as I recall. He appealed, and the appeal was heard. The appellate court said, nope, we think this is proper, so sorry about that. And it went to the Supreme Court. The decision of the Supreme Court a day or two ago came down and overturned what the appeals court and the lower courts had said. And this was interesting enough, and I thought would be interesting enough to our listeners, that I've pulled together sort of a summary of this because I wanted to go over exactly what this is that was decided. Chief Justice Roberts delivered the opinion of the court, and from the document which I've excerpted from, it reads, "This case presents the question whether the government conducts a search under the Fourth Amendment when it accesses historical cell phone records that provide a comprehensive chronicle of the user's past movements." And so, okay, so I'll skip over what we already know from a technology standpoint, but I'll just say that it opens with a clear and perfect, succinct explanation of cell tower location, how the increasing popularity of cellular communications has caused providers to increase the density of towers and thus increases the accuracy of tower-based location, approaching that of GPS, especially in urban areas. And I do have in the show notes at the beginning of this a link to the PDF of the full, it's 158 pages, I think it was, or that might have been in one of the other PDFs. It was like at least 119 of the opinion. Anyway, so here's the summary of the decision. It reads, "Cell phones perform their wide and growing variety of functions by continuously connecting to a set of radio antennas called cell sites. Each time a phone connects to a cell site, it generates a time-stamped record as Cell Site Location Information, CSLI. Wireless carriers collect and store this information for their own business purposes. Here, after the FBI identified the cell phone numbers of several robbery suspects, prosecutors were granted court orders to obtain the suspect's cell phone records under the Stored Communications Act. Wireless carriers produced CSLI, that is the cell site location information, for petitioner Timothy Carpenter's phone, and the government was able to obtain 12,898 location points cataloging Carpenter's movements over 127 days, an average of 101 data points per day. Carpenter moved to suppress the data, arguing that the government's seizure of the records without obtaining a warrant, that is to say a search warrant, supported by probable cause, violated the Fourth Amendment. The district court denied the motion, and prosecutors used the records at trial to show that Carpenter's phone was near 4 of the robbery locations at the time those robberies occurred. Carpenter was convicted. The Sixth Circuit affirmed, holding that Carpenter lacked a reasonable expectation of privacy in the location information collected by the FBI because he had shared that information with his wireless carriers. So, what the Supreme Court held is, 1, the government's acquisition of Carpenter's cell site records was a Fourth Amendment search. They say, which is to say, qualifies under Fourth Amendment protection, and a search warrant with probable cause needed to be obtained in order for the cell site records to be had. They wrote, the Fourth Amendment protects not only property interests, but certain expectations of privacy as well. And then they cite a previous case, Katz versus the U.S. Thus, when an individual, quote, seeks to preserve something as private, unquote, and his expectation of privacy is, quote, one that society is prepared to recognize as reasonable, unquote, official intrusion into that sphere generally qualifies as a search and requires a warrant supported by probable cause. Then they cite a previous case, Smith versus Maryland. The analysis regarding which expectations of privacy are entitled to protection is informed by historical understandings, quote, of what was deemed an unreasonable search and seizure when the Fourth Amendment was adopted, unquote. And again, a previous case, Carroll versus U.S. These founding era understandings continue to inform this court when applying the Fourth Amendment to innovations in surveillance tools. Then they said, next paragraph B, the digital data at issue, which is personal location information maintained by a third party, does not fit neatly under existing precedents, but lies at the intersection of 2 lines of cases. One set addresses a person's expectation of privacy in his physical location and movements, and then they refer to U.S. versus Jones, where 5 justices concluded that privacy concerns would be raised by GPS tracking. Then they say the other addresses a person's expectation of privacy in information voluntarily turned over to third parties. Then they cite U.S. versus Miller and also U.S. versus Smith. And this comes back a couple times, these Smith and Miller cases, where expectation of privacy in records of dialed telephone numbers conveyed to a phone company, and those were found not to be protected. That is, there was no expectation in using a telephone dialing numbers. Then they say for the next paragraph, C, tracking a person's past movements through CSLI partakes of many of the qualities of GPS monitoring considered in that Jones case, where it was decided that GPS tracking had privacy concerns. It is detailed so they're saying CSLI partakes of many of the qualities of GPS monitoring. It is detailed, encyclopedic, and effortlessly compiled. At the same time, however, the fact that the individual continuously reveals his location to his wireless carrier implicates the third-party principle of Smith and Miller. Given the unique nature of cell site records, this court declines to extend Smith and Miller to cover them. A majority of the court has already recognized that individuals have a reasonable expectation of privacy in the whole of their physical movements, allowing government access to cell site records which, quote, hold for many Americans the privacies of life, unquote, and their cite Riley versus California contravenes that expectation. In fact, historical cell site records present even greater privacy concerns than the GPS monitoring considered in Jones. They give the government near perfect surveillance and allow it to travel back in time to retrace a person's whereabouts, subject only to the 5-year retention policies of most wireless carriers. The government contends that CSLI data is less precise than GPS information, but it thought the data accurate enough here to highlight it during closing argument in Carpenter's trial. At any rate, the rule the court adopts must take account of more sophisticated systems that are already in use or in development, and the accuracy of CSLI is rapidly approaching GPS-level precision. The government contends that the third-party doctrine governs this case because cell site records, like the records of Smith and Miller, are business records created and maintained by wireless carriers. But there is a world of difference between the limited types of personal information addressed in Smith and Miller, that's the phone dialing, and the exhaustive chronicle of location information casually collected by wireless carriers. The third-party doctrine partly stems from the notion that an individual has a reduced expectation in information knowingly shared with another. Smith and Miller, however, did not rely solely on the act of sharing. They also considered the nature of the particular documents sought and limitations on any legitimate expectation of privacy concerning their contents. In mechanically applying the third-party doctrine to this case, the government fails to appreciate the lack of comparable limitations on the revealing nature of CSLI. Nor does the second rationale for the third-party doctrine, which is voluntary exposure, hold up when it comes to CSLI. Cell phone location information is not truly shared, as the term is normally understood. First, cell phones and the services they provide are, quote, such a pervasive and insistent part of daily life, unquote, that carrying one is indispensable to participation in modern society, citing Riley versus the U.S. Second, a cell phone logs a cell site record by dint of its operation without any affirmative act on the user's part beyond powering up. And so they trim this a little bit, saying this decision is narrow. It does not express a view on matters not before the court, does not disturb the application of Smith and Miller, or call into question conventional surveillance techniques and tools such as security cameras, does not address other business records that might incidentally reveal location information, and does not consider other collection techniques involving foreign affairs or national security. The government did not obtain a warrant supported by probable cause before acquiring Carpenter's cell site records. It acquired those records pursuant to a court order under the Stored Communications Act, which required the government to show reasonable grounds for believing that the records were relevant and material to an ongoing investigation. That showing falls well short of the probable cause required for a warrant. Consequently, an order issued under 2703, which is what was cited before, is not a permissible mechanism for accessing historical cell site records. Not all orders compelling the production of documents will require a showing of probable cause. A warrant is required only in the rare case excuse me, where the suspect has a legitimate privacy interest in records held by a third party. And even though the government will generally need a warrant to access CSLI, case-specific exceptions, for example, exigent circumstances, may support a warrantless search, and they provide some citings, reversed and remanded. So, bottom line, and good news for individuals, in my opinion, is that the Supreme Court ruled that the acquisition of CSLI data, that is the entire history of an individual's cell phone movement back through time, as far back as 5 years, can only be acquired by law enforcement if they have probable cause and are able to get a search warrant from a court in order to request the acquisition of those records from the cell carrier. So I think the Supreme Court did us right in this case, and I'm glad that this will happen. There have been recently an increasing number of instances. I don't think I've talked about it on the podcast, but I've encountered it in reading where law enforcement is just making sweeping requests for cell phone location information without just asking a court to say, hey, we're able to have this. So from now on, they'll need to show probable cause before getting it, and I think that's probably a good thing.
Hey, if I could interrupt just for a moment. Every year we do this, and we thought this would be a good time of year to do our annual survey, kind of a gift, if you will, to us. If you like what we have done, every once in a while we do these surveys. We try to get to know our audience better. And since you're techies, this one focuses particularly on...
Hey, Sheriff County, this is Sheriff County COPWATCH. I am using any video here with under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube, and there are different ways to donate in the video links. Thanks.